All right, the last time I was up here, I had the last time I was up here, I had Legos. Do you have any Legos?
I don't have any Legos.
Okay, so Michelle, you are one of the most important people on this stage. So you patent, you're in charge of the patent office, and you also came from private sector, so you know both sides of the technology creation world, right?
So actually, I feel at home here at CES. This is my second year back, but I'm a Silicon Valley techie. So being here amongst the entrepreneurs with all the great inventions, this is home.
Okay. So let's go through just a scenario based on your experience. When should guys like these folks get patents? How many folks out here are entrepreneurs, or are you guys making crazy things? Yeah, there's somebody. Okay, you're making crazy things. So when should these guys start looking into the patent process?
So you're going to have a pretty good sense of when you think you've got something new that nobody else has. You've got some secret sauce, some cutting-edge technology. And what I would say is, don't self-guess. Don't underestimate what you have. I would reach out very early on, and you can come to the United States Patent and Trademark Office. We have, in fact, in Eureka Park, a booth there. Come talk to us for free. You can ask some questions about your invention and the timing of when it might be appropriate, but early is better than later because you don't want to forfeit rights unintentionally. And also online, we have an IP assessment tool online for free. And you answer a few questions about your product or your invention and your business, and it will assess not only what patent rights you might be able to get, but what brand, what trademark rights you might get, what trade secrets you might have. So really you get the whole view of not just patent assets that your company might have, but other intellectual property rights. And these intellectual property rights are for you to decide to use as you deem fit to achieve your business goal. So it varies depending upon your business goals, but the key is you will have a gut instinct of when you have something, and don't underestimate that. Go with that instinct and reach out early and follow up early, because you could forfeit rights.
Can someone do their own patent application?
You can write your own patent application. It's what we call the pro se. You write it yourself. And in fact, we have a special unit at the United States Patent and Trademark Office who, if you are a pro se applicant, we will help step you through the process and give you a little bit more help. So if you're under-resourced, we have free attorneys who we can hook you up with. If you are not under-resourced, but you decide you want to write it to save some expense, we have a team that can help you through it. So we have all these resources for entrepreneurs and startups precisely because we want everybody to take advantage and have the benefit of our intellectual property system. So we have regional offices in Silicon Valley, Denver, Dallas, and Detroit. Whatever part of the country you come from, you don't necessarily have to go to Washington, D.C. to take full advantage of these resources, and many of them are free. Entrepreneur workshops, so a lot of free online content that we can direct you to. So definitely be informed, have a concerted strategy. It should be a critical piece of your business strategy. Your IP strategy, your intellectual property strategy should be a key piece of your business strategy.
Do you guys have a bell that goes off when somebody comes in with a perpetual motion machine?
No, we don't have a bell, but those usually don't get through. Yes, they do not get through.
Okay, so your background is in, you came from MIT, you had a dual major in, it was something really cool.
Electrical engineering, computer science, and I actually did my graduate thesis in artificial intelligence.
And then you went over, you got a law degree. So what's the process for somebody who's in artificial intelligence and then all of a sudden wants to get a law degree and then ends up at the patent? I mean, this is quite a perfect trajectory, interestingly enough, but why did you choose public service? Well,
I think in order to adequately serve inventors and entrepreneurs, I really do think you need to have experienced, it helps to have experienced innovation, to realize the difficulties of creating something new. It's very difficult, right? It takes a lot of effort, and to then hit a market opportunity, there are business realities, and then you need to see how businesses use intellectual property as a business tool. So I think the combination of all those perspectives really helps me do the job in the best possible manner. And I will tell you, as head of the US Patent and Trademark Office, I think what would I have wanted as an inventor, as an innovator, as a technologist. And you know what? I'm kind of doing all of that on behalf of American innovators because I think it's really important that our country continues to encourage the level of activity, the level of innovation that you see here at CES.
So very quickly, just so we get it out of the way. So if I have an idea, I can go to an office. I can actually talk to a lawyer for free potentially. What would be a brief step-by-step?
I would start off by going to uspto.gov. We have a whole bunch of online content there, resources, and there you will see our regional offices, all 4 of them, including as well our headquarter office. And so depending upon what your interest is in, if it's in patents or trademarks or what have you, you'll find information there, and then keep an eye out for workshops that we have for entrepreneurs, and we do have them regularly. So that may interest you to come in, and you may decide you want to take the IP online assessment tool, or you may decide that you want to write the application yourself, and the website has all that information. So I would start there, but definitely the in-person, you can always show up at any of our offices. We're glad to answer questions. You can walk right in and we'll help you.
Is there a particularly interesting patent that you've seen? Like somebody walked in off the street with something amazing and you saw them rise to stardom?
So that's like asking me which of my children is my favorite child.
Well, you don't have to describe it exactly, but you can say what their person's name is and what the product was.
You know, there's so much amazing innovation, and sitting where I sit and seeing the level, the inventions that are filed in all the technology areas, I mean, many of them in this conference, but also in the area of biotech and precision medicine, I don't think the future of our country, provided we continue to innovate, will remain bright.
All right, so on that same vein, continuing innovation, you're also very active in getting women in tech. So why don't you walk us through some of the efforts that you've been working on specifically to get more women entrepreneurs and innovators out there?
So as you had mentioned, I spent my entire career in tech, in the Silicon Valley, primarily in the area of electronics and software and the internet. And I have the privilege of being the first woman head of the United States Patent and Trademark Office in our country's 200+ year history.
So the first woman in 200 years.
Yeah, and the Patent and Trademark Office goes all the way back to the founding of our country, or very, very soon there, shortly thereafter. So it's a real honor and privilege, but I also feel a heightened duty and responsibility to try to encourage more women to pursue and take advantage of opportunities in tech. And fewer than 25% of the STEM positions are held by women, despite the fact that women hold about 50% of the jobs. So we have a long way to go. And those women who enter the STEM professions oftentimes do not stay. If you look, there's a survey that was done that 12 years into their career, 50% of the women in STEM are no longer in those jobs, compared to 20% of women in non-STEM related areas. So our girls are they're good at math, they're good at science, but as you move up through the pipeline, right, through the ranks, the numbers are fewer and fewer. And I think as a matter of economic imperative, we need to be tapping into all of our talent. Our tech companies can't hire the technical talent they need to staff their teams. So why wouldn't we take advantage of all of our resources and develop all of their talents? And not everybody's meant to do science and technology, engineering and math, but you know, if we provide more encouragement and more support, then more of our children, and that's not just girls, I mean, these are people across all regions of our country, not just the West Coast and the East Coast, and across all demographics, because these are some of the higher paying jobs, these are some of the areas where you see the greatest job creation and so forth, and why wouldn't we want all of our citizenry to have the opportunity to be a part of this excitement?
So your father was an entrepreneur. I think there was an interesting origin story for your interest in electronic engineering, right?
So he was an engineer, and I grew up on a street where all the dads, and there were dads back then on the street, were engineers. And I grew up and I built a handheld radio with my dad when I was a young girl, and I just sort of thought that that's what all girls did. But I realized that that was not the case, but why shouldn't they? Why shouldn't they be passionate about making things and building things and designing things and inventing things and, you know, perhaps starting their own companies and being here at CES and growing a company? Those are exciting activities.
So what are some good programs that you've seen around the country that can help in that effort in the STEM for Girls?
So the USPTO works with Invent Now, and we have this wonderful program called Camp Invention. And it's literally offered throughout all the 50 states. Some 100,000 plus kids sign up each summer for a 1-week summer enrichment program. And we do particularly also target those from underprivileged backgrounds. And basically the kids, elementary school, age school kids, are given a design project. And they have to go into a room, grab the materials, sketch out a design, prototype it, build it, test it, redesign, rebuild, and it has to achieve a goal. And you should see the excitement on those kids' face. I mean, this is not textbook learning of science. This is the kind of making and creating that probably served as the foundation for many of the inventors and entrepreneurs at this conference. So really exciting the passion for making, creating, and inventing. And that's one program that we have a role, that we play a role in.
Okay, so one of the biggest aspects for us as journalists and us as tech enthusiasts is this idea of the patent troll. First off, do you guys call them patent trolls? Do you have like signs or whatever? Like,
I don't like to use the word patent troll because a patent troll really has no definition. I think the issue that you're trying to get at is there are those who abuse the patent system. So, I mean, and that can occur by people who, the term patent troll is often used to refer to people who buy a patent, they don't invent anything, they prefer patents that are vaguer and broader, and they assert it against a whole bunch of what we call operating companies. And because litigation in the United States is so expensive, and patent litigation in particular is particularly expensive, they will say, you know, don't look at the claims too closely, we'll call it a day, let's settle, and for X 100,000 or, you know, even X million, we'll just settle the case. And if you say that to enough people, for the cost that you pay for a patent, relatively modest, and the amount that you can collect from other folks, that can create a pretty lucrative business. And so that's not really what our patent system was designed to support. Now, on the other hand, so we want to discourage abuses of patent litigation, right? And that can occur too for those who are defendants. If you're a defendant in a patent case and you're up against a small inventor who really invented something and has a patent on it, and you're a big player and you're encroaching upon their space, right? If you stonewall them and you continue to fight and you drag out the cost, that too is abusive. So the goal is really to curtail abusive litigation regardless of who is committing the abuse. So the administration, and a good part of what I do, is trying to help improve the system so that we can curtail some of these abuses.
so what happens in a situation? I know some of the specific examples, that the most egregious examples were something like I believe it was like a little disk icon that was a save icon, and that became sort of a patent, the idea that you can save to a disk. And this was years ago. I remember This American Life program about it. There were some really kind of very basic computer concepts that were patented and then were purchased by a patent troll, essentially. What happens in between the patenting of very, very simple concepts and the opportunity to basically use those as sort of a bludgeon to attack companies that are doing that simple concept because that's part of their business?
Yeah. So simplicity or complexity is not a criteria for determining whether or not you get a patent. It needs to be new, useful, and non-obvious. That said, if you are facing an assertion of patent infringement and you do not think the patent is valid, there is now a new proceeding where you can bring that patent back to the United States Patent and Trademark Office, and for a lower cost and in a shorter time period, you can have the office re-examine the validity of that patent. And if in our re-examination we determine that that patent should not have issued, guess what? That patent will be removed. Now, you have to provide the evidence that that patent is invalid, but there are some thresholds, but this is newly added, and this has provided a tool for those who believe they are unfairly on the receiving end of a patent infringement claim.
So that's interesting. So if I had the definition was new, non-obvious?
New, useful, and non-obvious.
Okay.
And you also have to fit certain statutory categories.
So if I can say that a patent that was filed years ago, back when computing was still new, I'm trying to wrap my head around that, because that's actually interesting. Because what if I said, I don't know, the writing of ones and zeros to a magnetic disk? That's a patent, right? But that might have. But if I say it now, it's non-obvious. It's obvious to us now, but it was.
Well,
you know where I'm going with that?
So obviousness is a difficult determination.
Sure.
That's why when you ask me, if I'm an entrepreneur and an inventor, when do I file and how do I file? what I would say is you're going to have an instinct and you're going to know the competitive landscape to some degree. So don't second guess those issues about whether it's obvious or not. One of the things is I worked with many engineers and they're the toughest critics on themselves. They think, there's nothing new here. I don't need, there's nothing new. And then they don't file for the patent and then maybe somebody else does and then you end up on the receiving end of an infringement claim. So the moral of the story is, again, those are legal determinations that are very highly specific as to the facts and what was done before and other references that were found and so forth. So don't second guess yourself. Make an informed business decision. Consult, make sure you understand your options. Have a conversation with a lawyer, right? All these things, right?
All right, perfect. Thank you very much, Michelle. This has been amazing, and thank you for your service. It's great to hear this straight from the horse's mouth, I guess you could say, right out of the patent office, and we can help thousands of people here.
Glad to be here. Thanks for having me.
Thanks a lot.